Hi there, welcome to the Disability Law Show once again. I'm John Scholes. That is James Fireman, disability lawyer at disabilityrights.ca. We always start off with the contact information so you can get it ahead of time and keep it. Need to contact James and his team. Consultations are free. Chit chat, it's okay. 1-855-821-5900. 1-855-821-5900 and help at disabilityrights.ca to back it up with an email. We always have a main topic on this show. In the second segment, we'll get to that. This week, it's going to be navigating LTD benefits for chronic migraines and headaches. Phone calls, emails, lots of different questions. And I know James every week brings a ton to the table, which we're going to throw it over to you right now. Pal, what do you got for us today? What's happening?
Well, John, we spend a lot of time on the show talking about what happens when your benefits have been cut off or denied. But we don't spend as much time talking about when you are on claim. And one of the questions that we do get a lot from people who are receiving benefits is, how long am I going to keep getting those benefits? How long is the insurance company going to continue to pay those benefits? And there's a lot of misinformation out there. A lot of people will have been led to believe that they're guaranteed to continue getting their benefits until they're 65. Other people are led to believe that they only have benefits for up to 2 years and somehow their benefits are going to stop there. Neither is typically the case. In fact, the reality is, for just about everyone, it's the same situation, which is to say, if you are getting your disability benefits, you're month to month, your insurance company can, at any time, decide to terminate your benefits, and you need to understand that. Now, that doesn't mean that I'm not trying to raise alarm bells here. I'm not saying next month your insurance company is going to terminate your benefits, but it can happen. And it can happen a lot more quickly than you might believe is going to be the case. And so I have an example of something that happened to a client of mine whose case I recently settled. So she was suffering from severe mental illness. She had had several issues through her life, but had continued to work, but suffered a series of traumatic events that caused her to have to go off work. And I'm trying to be a little bit vague because I want to protect her identity here. But she went off work, she applied for disability benefits, and was in fact approved. It was very clear. All of her treating doctors had agreed that she was far too disabled to return to work. She was suffering from severe PTSD. There was no question that she was disabled from working, and her insurer agreed. Paid benefits, continued to pay benefits throughout the entire own occupation period, as they should have. And then, without warning, they sent her a letter a couple of weeks before her 2-year period expired, before the end of the change of definition period, the own occupation period, telling her that they had determined that there was no longer sufficient evidence to prove that she was disabled from working and that they believed she could go back to another occupation. They had not at any point suggested to her that they were somehow requiring anything further than what had been provided, that there was anything missing, that further notes would have helped them in the process. They simply just told her a few weeks before they were going to cut off her benefits that that's in fact what they were going to do. There wasn't even the typical alarm bells that you might get where they're sending you to see a doctor for an assessment or telling you that they're doing a transferable skills analysis. Both of those, by the way, if you are receiving benefits and your insurance company goes down that road, you can bet that the insurance company is at least considering very carefully whether or not they can cut you off. Neither of those happened in her case. She just got a letter telling her that her benefits were being terminated, and that was that. So she gave me a call, thankfully. I looked at the file to understand what was behind this decision. And what had happened here is very clearly the insurance company had decided that this was someone who they knew they were going to have to pay benefits to for years and years to come. And rather than go through the proper process, rather than have her assessed by a specialist who undoubtedly would have confirmed the severity of her post-traumatic stress disease, they instead sent her to a consultant. In fact, they didn't send her to a consultant. They sent her file to a consultant. And the consultant now, I'll say this, he was a licensed doctor. That's about as much as I can say, because he's not a specialist of any kind, let alone in mental health. He doesn't have any hospital privileges. He doesn't even have a practice. His practice is run literally out of his home address. All he does is he consults with insurance companies when they have claims like this, and somehow, far more often than not, finds that the person is not disabled and is perfectly capable of going back to work, despite all of her treating doctors uniformly confirming that she could not work. This consultant, with no specialized expertise in mental health, determined that she was able to return to work. And based on that, and that alone, they terminated benefits. Here's the thing. When an insurance company does things like this, they're not supposed to, they know it, but typically they get away with it because most people leave it at that. Most people get that letter and feel like there's nothing that they can do, but there is. Because the reality is the policy doesn't allow them to do that, but they do it anyway. If you call them on it, if you hire a lawyer and you start litigation, they come to the table very, very quickly, and that's indeed what happened in this case. We were able to resolve her case, I believe it was 10 months from the date that she called. We got to mediation, settled her case for a very significant amount. They not only paid everything she was owed up to the date of the mediation, but they paid for several years into the future. So that was an excellent result for her, and it was thankful that she had watched our show and gave us a call.
The first thing that triggered this was the fact that they knew it could be months and months until or years till she's off claim.
It was obvious.
Wow.
There was no way you could have looked at the medicals and come to any different conclusion. It was universally accepted by all of her treating doctors that she was not going to be able to return to work for a very long time, if ever. If ever. That was the extent of her post-traumatic stress disease.
So based on what you just said about this consultant working from home, no hospital privilege, doesn't even have a working practice, how in God's name did they think that would even hold up in court versus reams of data from her own treating specialist that she should not be working? What were they hoping for?
They don't for a moment believe it would hold up in court, which is why once litigation started, they came to the table so quickly. The calculus is that they believe correctly that most people won't do anything about it. Most people are going to get that news that their benefits have been terminated and just accept that there's some decision that's been made and it's beyond their control. And if the insurance company who does this all the time has come to that conclusion, who are they to argue with them? Or worse yet, that even if they disagree, how are they going to take on this billion-dollar insurance company that has all of these resources when they're just one person? The reality is it's a lot simpler than that. All it takes is one phone call.
They didn't throw out your favorite bone, the appeal? They didn't do that?
Thankfully not in this case. And I'm sure we'll get to that later in the show, but the appeal is usually a waste of time, as our viewers typically understand.
Yeah. PocketDisabilityLawyer.ca. Just want to switch gears for a moment. This is a place where you can go through a bit of a fishnet of things to qualify, or at least see if you should be giving James a call to carry on if you have a case as far as disability is concerned. Really simple to use. It's anonymous. Takes a couple minutes just to answer a few questions. PocketDisabilityLawyer.ca is what's that called. I want to get to our first email for the show, James. You'll answer it. I'll read it. And Melanie writes in, says, guys, can I ask my insurance company for a different independent medical examiner? The one they chose provided a report that contradicts what my family doctor and chiropractor have said. I'm worried they'll use this as a reason to cut off my benefits. This is sounding really familiar.
Well, there's no reason to worry that they're going to use it as a reason to cut off your benefits. They will. They will. So don't spend any time worrying about it. Your insurance company, if they didn't use that as a reason, would have found something else. So don't be overly concerned about that. Just understand that this is part of the process, unfortunately. Now, in terms of what can you do about asking them to get a different medical examiner, that's tricky. So if we're talking about an insurance company saying, we want you to be treated by this doctor, then you have a lot more control over it, particularly if there's a reason beyond simply you expect that they have bias, which they typically will. Usually there's a good basis as an insured receiving benefits to say, I'm not comfortable with this particular provider for whatever reason, or I want to continue with the treatment that I'm getting from my own providers, and my doctors say that this treatment is unnecessary. There's a much better basis to make that argument when we're talking about treatment. When we're talking about assessment, it is a different story. The insurance company does have a reasonable basis to say, we want to have you assessed so that we can understand from our own people what is going on medically. That is a reasonable position for an insurance company to take. And except in pretty exceptional circumstances, I wouldn't say there's a good reason to dispute any particular medical examiner. The exceptions I could think of, if there was previous findings in the College of Physicians and Surgeons that suggested that the the particular doctor had been inappropriate, if there was some reason to believe that their expertise wasn't relevant to the issues that you're dealing with. Those would be good reasons for it. Perhaps if the expert that they had chosen was too far away.
That's what I was going to ask. Is there exact, when it comes to actual examination, is there criteria which is, a push too far? Like, you live in Toronto, but you got to go to Alberta to get, you know what I mean? Like,
I mean, that would be pretty unusual.
You know what I mean, yeah.
Particularly if you live in Toronto, you would expect that you're going to have access to any particular expert. The reverse, however, if you're living in a rural area, it could be pretty reasonable for the insurer to say, well, we're going to need you to go to Toronto. Now, if that is the case, if there's a particular expert and in your own local area, there is no expert that would fit that bill, and you have to travel some distance to get there. It's not up to you to figure out how to get there. If they want you to travel, it's up to them to figure out how you're going to get there. They have to arrange for your travel, and if it requires overnight accommodation, they got to fit that bill too.
Okay.
So either way, it's reasonable for the insurer in virtually all cases, as long as it's the relevant expertise. As long as the person they choose has that relevant expertise, it's usually reasonable for them to say, this is the person we want. And other than insisting that they pay for whatever transportation is involved, there's not a lot you can do when we're talking about assessment.
In your experience, is it usually just once they do this, or can they get away with it more, several times?
In my experience, they typically don't do that at all in most cases, and the reason is pretty simple. It costs them money. Assessments cost money, and insurers like to spend as little as possible. Now, when they do that, that's fine. They're entitled to do that, but it's pretty unusual to see an insurer go through more than one. I've seen it. Does happen, and typically it's in more significant cases, either because the disability itself is more severe or more difficult to understand, or we're talking about a very high monthly benefit amount and the value is exceptionally high. But it's unusual to see more than one. Even one is probably less likely than none.
Let's take a wee break. We'll get to our main topic on the other side. That is navigating LTD benefits for chronic migraines and headaches. That is coming up right here on the Disability Law Show. Stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Give me the same content. Okay, we are back. The Disability Law Show rolls on. John Scholes, James Fireman. Reach out to James, disability lawyer, of course, anytime. Consultations are free if you just need a few questions answered. That is fine as well. 1-855-821-5900. Help at disabilityrights.ca. Okay, James, we're going to get into our main topic. This is where I pick on you for the next few minutes. Navigating LTD benefits for chronic migraines and headaches. Here we go. Number one, insurance companies often deny long-term disability LTD claims for chronic migraines. You know why? They're arguing there isn't enough medical evidence to support them. How often do you see that?
A lot. This comes down to the experience of any kind of headache, migraine, or otherwise is largely subjective. In certain circumstances, you can find some objective proof of it, but the experience of it itself and the extent to which the headache or migraine is going to impact your ability to function. That's really what this is all about. That's what any disability claim is about, is how your disability impacts your ability to function. And so whether you have a headache, a migraine, or any other condition, that's really where the analysis should be focused. Insurance companies like to move it away from that because the reality is that's always going to involve a large degree of subjectivity. It's going to rely largely on the extent to which you say it is limiting your ability to function. Insurance companies like to say, well, there isn't any objective evidence. There's not objective clinical evidence. There's a lot of different ways that they like to put this. But typically, they're going to come back to that word objective. They're going to say there's just not enough objective information. And that is always a bright red flag for me. When I see that, I know right away that something incorrect has happened on the file, because they're not allowed to rely on that. There is nothing in a disability policy, typical disability policy anyway, that requires objective proof of a disability. That's just simply the way that this works. When we're talking about, for example, a mental health claim, you're not going to have objective evidence of a mental health claim. It just doesn't exist. It cannot be required by an insurance company, nor is it something that is in any typical policy. And yet insurance companies will routinely cite that as a basis, the lack of objective evidence as a basis for denying a claim. Why do they do it? The same reason they do everything, because typically they're going to get away with it. If you see that, if your insurance company is saying there's not sufficient objective medical evidence or objective clinical evidence, however they want to put it, understand that they are not entitled to rely on that as a basis for challenging your claim. It is simply not correct. Now, does that mean that you can just simply wake up and say, I'd like to get disability benefits? I now have severe migraines. I say they are, so they must be, and nobody can challenge that. No, that's not how it works either. It still has to be supported by medical evidence. But whether it's objective or not is an irrelevant consideration. The only thing that matters is that there is medical support. So if you are going to see your doctor on a regular basis about these headaches, if your doctor is sending you for specialists because they believe the condition is sufficient to warrant involving a specialist to treat your condition, if you are prescribed medication to treat your condition. Those are all markers of a medical condition which would entitle you to benefits if it sufficiently limits your ability to function. None of that requires objective evidence. There isn't a black and white test. There's no X-ray that's going to show this person suffers migraines or this person doesn't. That just doesn't exist. But even subjective evidence can be more than sufficient. And by the way, this isn't just me citing something out of nowhere. This is the Supreme Court of Canada has said on multiple occasions subjective evidence is sufficient to warrant a claim.
Number 2 point is this, James. It's crucial to have detailed medical records, specialist reports, and even a symptom journal that tracks how often and severe your migraines are. I know most people that have historically suffered from migraines. Thank God, I don't, but they do that automatically. They're always writing down when they haven't and the length of it, right?
Yeah, and that's not for legal purposes. That's, as I understand it anyway, because like you, I thankfully do not suffer from that. But as I understand it, that's just part of the treatment protocol. And so that's something that you would expect to see from somebody suffering from severe headaches or migraines as part of the process. But this really plays into what I was just talking about. Yes, you can certainly have a successful claim where it's based on a subjective disability, but you do have to make sure that it is properly documented. It's not enough to just say, I have this disability, give me disability benefits. It does not work that way, nor should it.
Right.
You should be going through the medical process, because if you legitimately are suffering from severe headaches or migraines, then you should be getting treatment. And if you are doing that, if you do have that condition, if it is functionally limiting you to the extent that you are not able to work, then of course you're going to be going to your doctor. Of course you are going to be hopefully aggressively seeking out treatment, seeking out medication in order to treat your condition and minimize the impact on your life.
And finally, the third point we want to make here when it comes to navigating LTD benefits for chronic migraines and headaches, James, is this, that if your LTD claim is denied, which it probably will be, don't accept it as the final word, which you've been saying, right?
No, that's 100% true. And so insurance companies love to prey on people's misunderstanding of the process or their vulnerability, or sometimes both. And they know that in the vast majority of cases, even if they understand from all of your treating doctors that you are disabled from returning from work, they know that if they say, well, our review of the medical evidence suggests that there's insufficient evidence to support that you are disabled from work, most people are going to hear that and do nothing about it. Or they'll hear that and say, okay, well, I'm going to appeal. Because invariably, when benefits are terminated or denied, there's an invitation to appeal that appears just after that. Most people are going to take up that option to appeal because they believe that that is the easiest way to go about it. It is, in almost all cases, John, as you well know, a complete waste of time, because understand the appeal is going to go to the same person, in most cases, who made the decision to deny your benefits in the first place. And unless you're providing information that is substantially different than what your insurance company already had when it made its decision in the first place, there's no reason to believe that they're now going to change their position, given that what they want to do in the first place anyway is to cut off benefits. That's what the insurance companies want to do. There's no secret there. I'm not telling anybody something that they don't know. Insurance companies don't want to pay benefits. Big surprise. Once they find the justification to terminate those benefits, to get them to change their mind, it's going to take something significantly different than what they had already understood. You have a new cancer diagnosis? Okay, give it a shot on the appeal. That might work. Short of that, it's a waste of your time.
Wow. We'll take a short break. We got lots more coming up. MyDisabilityQuestions.com. That is a wonderful website, free and anonymous for you to use. We'll grab a question from that website on the other side of the break. Stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Yes, this is the Disability Law Show. Welcome back to it for a few more minutes. We got a website, which I just mentioned before the break. But first, contact information. Reach out to James and his team. Consultations are free. Take full advantage. 1-855-821-5900. Help at disabilityrights.ca is the website. But this website, once again, mydisabilityquestions.com. Yet another avenue for you to go down freely and anonymously to ask your questions. They will get answered no matter what off air, but some make it to the TV show as well. So for this show, Katie writes in, James says, my daughter was on short-term disability after being diagnosed with panic and anxiety disorder. She was under the care of a psychiatrist, psychologist, and her family doctor. When her benefits ended, she applied for LTD, but they denied her coverage. Her insurer says she mentioned anxiety to her doctor years ago before she even started this job, and they're calling it, you bet, a pre-existing condition. Her actual diagnosis was made recently. Does she have any options?
Very interesting question. So first of all, I want to thank Katie for writing in on behalf of her daughter. If you are watching out there and you have a loved one who is engaged in the process and has questions, or you want to ask some questions, you certainly can, and you can keep their identity confidential if you have any concerns about that. We're happy to provide information where we can, as we were happy to do for Katie in this case. To answer this question about Katie's daughter and about whether or not the years past questions about her anxiety might trigger this pre-existing condition exclusion in the policy is an interesting question, because unlike most of the issues that we deal with on the show, where we're talking about a typical long-term disability policy where in substance it's almost exactly the same policy to policy, the pre-existing exclusion can vary significantly from policy to policy. And so first thing you got to do is look at the policy itself. So if you are in a situation where the insurance company is suggesting that your claim is excluded because of a pre-existing condition, or even that it might be, you want to ask for a copy of the policy, and you want to take a look at that provision really closely, because it can be worded differently and that wording can change the meaning of it. Sometimes the only issue is a condition that you had in a short period of time prior to becoming insured. So typically, you get insurance when you're hired for a new job. Oh. And once you have that insurance, it's only the first year that you have to worry about. If you become disabled after the first year that you have the insurance, it doesn't matter whether you have a pre-existing condition or not. Okay. It's only if it happens within the first year. If within the first year you become disabled and that disability is related to a condition that you had before, then they're going to look at the wording of the pre-existing exclusion. Sometimes that exclusion will apply to eliminate any claim if you've ever had it before. Sometimes only if you've had it within 3 months or 2 months or 6 months before you became insured. So it's really important to look at that. And then you want to take a look at the wording as well too, because sometimes it could say directly or indirectly related to a condition you had before, which is a much wider definition. So that's not great if it's worded that way. Sometimes it can talk about whether or not you've had a diagnosis. Sometimes it can talk about treatment. Sometimes it will talk about treatment even more broadly, talking about treatment which could include medication. So let's say in Katie's situation here, her daughter, let's say she had been treated for depression years before, and even though she wasn't getting any ongoing mental health treatment, she was being prescribed antidepressants, for example. The insurance company might use that as a basis to say that she was receiving ongoing treatment through the relevant period of the policy, and therefore her claim is excluded because it's a pre-existing exclusion. Now, here is where it gets even more interesting, John, because when we're talking about mental health, there is a tendency for insurance companies to say, well, you've had one mental health issue before, and therefore it's at least indirectly related to what you're having now. In other words, let's say you're suffering from depression now that's causing you to go off work, and in the past, you've had anxiety, even anxiety within the period of time that is relevant. They will say, well, that's at least indirectly related, and therefore your claim is excluded under this pre-existing condition exclusion. That's not the way that it works. Depression is not anxiety. The Joker is not the Riddler, as I like to say. They're just not the same thing. They can be related, and sometimes they will go hand in hand. And so you really have to be careful. You want to go through the clinical notes and records of the treating doctor and take a look whether or not there are references to both types of conditions, to both anxiety and depression. If there are, it's going to make it more difficult to argue around that. But if you haven't had the actual condition in the past that you are being that you are taking your leave for now, then there isn't a basis for your insurer to say that it's a pre-existing exclusion.
First of all, who hasn't had a bit of anxiety? This was years ago, right here in the text. Years ago, not 6 months, not 3 months, years ago.
Yeah, no, that's entirely correct, John. The one thing I will say, and what should be clear after what I've attempted to make a reasonably clear explanation, but I'm sure has gotten muddled, this can be pretty complicated. Yeah. It does require you to look at the policy, to look at the medical records, and to go through it and to relate the two to each other. We're happy to do that for you. If this is something that is coming up in your claim, if you've applied for benefits and your insurance company is saying, we're not going to pay, there's a pre-existing exclusion here, give us a call. We're happy to take a look at it. The consultations are completely free. If there's a way around it, we're going to tell you, and hopefully the insurance company will reconsider it. And if they don't, then you can look at starting litigation. But by all means, we're here to help in that situation.
You ever find mental health claims are low-hanging fruit for the insurance company?
Oh, yeah. They will very quickly deny claims for mental health, far more quickly than they will for physical. Again, getting back to what we talked about earlier in the show, you're talking about a subjective condition, and therefore they'll just lean into that no objective medical evidence.
As James said, thank you, Katie, so much for writing that into us. We appreciate that. You can keep sending them along as well. May appear on our next show. MyDisabilityQuestions.com is what that was from. Barring that, email and phone number 1-855-821-5900 to talk to James, and help@disabilityrights.ca. Back them up together, and we'll catch you next time on the Disability Law Show. Thanks for tuning in.